The name of the game for Donald Trump and his legal team and all the court cases he's facing has been delay. The decision by a Georgia judge to allow Fani Willis to remain on the election interference case will also further delay that trial. In the federal classified documents case, Judge Eileen Cannon in Florida has yet to rule on a number of motions heard in court yesterday. And the one motion she did rule on could be problematic during the trial. And in New York, just days before the hush money trial was set to begin on Monday, and after reams of new documents were handed over by the Southern District, Manhattan DA Alvin Bragg signaled he is open to a 30-day delay, which has been agreed to by the prosecution. Not quite as long as the Trump team asked for. So joining us now, MSNBC legal correspondent Lisa Rubin, and with us once again, Andrew Weissmann and Paul Butler. Lisa, let's talk about the hush money case. We're learning that the Southern District of New York is handing over another 15,000 documents today to the Manhattan DA's office. That's the second new tranche. And Trump lawyers are going to receive this for the first time. I think there were some 73,000 before. What does this mean for the hush money case, and why did the SDNY not put this material out a lot sooner? This was material from a previous Southern District consideration before Alvin Bragg took over, apparently. Yes. But it's information that they had that had come from Michael Cohen that did not lead to the prosecution under Cy Vance, I guess. But it did need to go to the Trump team. Doesn't this seem like a big error?
Well, first of all, Andrea, we don't know yet what the communications were like between Alvin Bragg's office and the Southern District of New York last year. In a filing that they made yesterday, Alvin Bragg's office said, essentially, we asked last spring for a lot of the same records that they have now produced to us. We didn't get them then. We only got a subset of what we asked for. Everything that we had, we turned over to Trump and his legal team at the time. They didn't complain. Instead, they sat on it and did nothing until January, when they served a subpoena on the Southern District of New York. And after some correspondence back and forth to convince the Southern District that the requests that they were making were indeed relevant to the preparation of their defense, did they then get what is now almost 120,000 pages of documents. So why this happened, I think, is still an outstanding question. When Alvin Bragg responds substantively to the motion that Donald Trump's team filed, we might have some more insight into that. Their response on the underlying discovery violation motion is due next week. And I also want to emphasize to you, in terms of derailing this case, Trump put in a letter today to Judge Merchan where they basically said, it's nice and well that the DA will agree to a 30-day adjournment, but we're not asking only for an adjournment. We're saying that if you find an adjournment is all we're entitled to, we want 90 days. But principally, we're asking you to dismiss this case based on the totality of discovery violations we are bringing to your attention, of which this whole kerfuffle with the Southern District is just one part, Andrea.
Wow. So Andrew, weigh in on this. What is your take on what Judge Merchan, who's been pushing forward, might do with this?
Well, I think with respect to the underlying motion that Lisa's referring to, that's a pretty standard motion that defense lawyers make under relatively new rules in the state system. So I don't expect that's going to go anywhere. You never know, but I'm confident in a case like this that the DA is going to have turned over everything that they're required to turn over. So I'm not that worried about it. I do think to this idea of like a tranche of huge documents being turned over a couple days ago from the Southern District, a new batch, I think that, to not be facetious, but I think there will be tranche warfare because you really will be seeing the DA, I think, as they have in their papers, taking to task what the judgment call was with the Southern District. I think the big open question is really and the one that I have is, what was the Southern District of New York thinking a year ago when, by all accounts, they were asked for the material that would be needed, whether it's inculpatory or exculpatory? That is something that the DA would want to know, and they also would want to make sure that they provide all of that to the defense. So, that's really the open question. I do think that it may be that, a couple of months from now, after the trial has started, that we all look back and we still have that question. We still may fault the Southern District of New York prosecutors in terms of their judgment call, but it may become sort of a mountain out of a molehill. But I do think, in light of what's going on here, in light of the decision today in Georgia that we talked about earlier in your show, it's not a really good day for both state and federal prosecutors in sort of looking like they're wearing, they have the white hat and are acting sort of responsibly. There are a lot of questions, I think, that people rightly have in both fora.
And Andrew, I also want to follow up and ask you about Judge Cannon in Florida, because I heard you last night talking about how this dismissal on the one issue was actually potentially damaging to the prosecution, because if she dismissed it out of hand, since it was such a frivolous motion in your view, it would have been overturned by the 11th Circuit. And she was probably trying to avoid, again, for the third time it would be, being overturned by the 11th Circuit. But right. By going along with it for now, but not totally dismissing it, saying that she might revisit it once the trial gets underway and more evidence is introduced, once the jury is seated, it would be double jeopardy, as you were explaining it. So therefore, she might be able to dismiss it and they would have no appeal. Am I right that this could be really damaging down the road?
That's exactly right. I think the most important thing for people to understand is that what the judge said is this was dismissed without prejudice. What that means for non-lawyers is that it can be raised again and it will be decided anew. When you dismiss something without prejudice, as opposed to with prejudice, it means that the defense can still raise it. So it may look like a victory, but it's really just, it is literally the kicking the can down the road. And so if she had actually ruled against the government, that's something that the government could have immediately appealed and gone to the 11th Circuit, as you noted, Andrea, but she didn't do that. If she had sided with the government, of course, that would have been something they wanted. And of course, I think many people, including myself, think that the motion itself was so frivolous. But here she basically is saying, I'm going to basically revisit this at a time that it may be much more harmful to you, the government, in terms of your options about how to appeal this.
And Paul, let's talk about a new statement now from Ashley Merchant. She is the attorney for Michael Roman, one of the co-defendants, one of the other defendants in Fulton County. She had brought suit in Fulton County to get Fani Willis dismissed. She says, quote, while we believe the court should have disqualified Willis's office entirely, this opinion is a vindication that everything put forth by the defense was true, accurate, and relevant to the issues surrounding our client's right to a fair trial. So, Paul, weigh in on this.
Ms. Merchant is overclaiming on the merits. She lost. She wanted the case to be dismissed. The judge refused to do that. She wanted D.A. Willis kicked off the case. The judge refused to do that. The judge certainly gave her ammunition in terms of a critique of D.A. Willis. The judge strongly rebuked both D.A. Willis and Mr. Wade, but it's Mr. Trump who remains on trial. And so I think that Trump himself, who Ashley Merchant doesn't represent, may score some political points from the judge's opinion. But at the end of the day, the only voters who matter are the 12 people who will be on the Fulton County jury that considers this case. And we'll have some sense of where they are on D.A. Willis with the election, which is coming up, which will almost certainly occur before the trial.